Thank you very much, Andre. Good day, everyone. I don't want to say good morning or good afternoon because you may be in different time zones than I am, but I wish everyone a good day. And it's my great pleasure to have the opportunity to present to you today on a topic that is very meaningful to me, legal ethics and the mediation program. Just by way of brief background, as was mentioned, I was the presiding justice of the Appellate Division Second Department in New York, which is one of the four intermediate appellate courts in New York. It is also the body that has jurisdiction over attorney admission and attorney disciplinary matters. And as presiding justice, I had the administrative responsibility over the progressing of those matters, and I sat on innumerable attorney disciplinary cases. And since I retired at the end of 2020, I have been affiliated as a neutral with NAM, National Arbitration and Mediation, and I teach ethics at the Pace Law School in White Plains. As all attorneys know, the rules of professional conduct have provisions which address various aspects of attorney behavior. The ABA has promulgated model versions of the rules, and the states, I think all but one, have adopted the ABA code, although each state may have some individual variations. In general, the rules address attorney behavior, but they don't really get into detail as to the conduct of counsel during settlement negotiations. The ABA section of litigation has promulgated guidelines to help fill the gap. Those guidelines are predicated upon the ABA model rules and upon ABA ethics opinions to help provide some relatively black letter guidelines for attorneys to follow. The ABA ethical guidelines are not disciplinary rules themselves, so they are not punishable directly by professional discipline of a lawyer, but they are intended to be practical, user-friendly guides for attorneys seeking advice on ethical issues arising out of settlement negotiations. And as you'll see shortly, these guidelines are consistent with, of course, the rules of professional conduct, and those rules are disciplinary rules which can set the basis for professional discipline. And I would add that the ABA has also adopted model standards of conduct for mediators, which are designed to guide the conduct of mediators and inform the mediating parties as to the conduct they should expect from mediators, and thus overall promote confidence in mediation as an appropriate and trusted dispute agreement process. The purpose of mediation is to obviously attain a settlement or a resolution with the assistance of a third-party neutral. Mediation is often used to resolve a one-time dispute that is or may be headed to court to try to resolve the matter amicably without continued litigation. Mediation is also used for the purpose of salvaging a continuing relationship. I have seen matters where there are two partners who aren't getting along, and their disputes can be mediated in an effort to try to keep a profitable business going. And mediation has the advantages of saving the time, the expense, and the risk associated with litigation. It also is worth noting that when parties have agreed to resolve their disputes, the compliance rate with the resolution achieved is much higher than it is in terms of a judge's decision that has enforced a resolution to the dispute. A question that is often asked is, what is the best time to mediate? Well, and this is almost the universal answer to every legal question, it depends. And the question then becomes, well, it depends on what? Well, about 10% of the NAM mediations come in pre-suit, maybe even pre or during discovery. The advantage of an early mediation is to obtain an early resolution and thus save all of the expense, time, and risk associated with litigation. In some instances, there may be a contractual provision that requires a pre-dispute mediation before the case can be put into suit. The vast majority of mediations do occur post-discovery and prior to trial. At this point, each of the parties has whatever information they're going to have about the strengths and weaknesses of each other's positions. And with discovery completed and the pressure of a court date coming up, parties come into mediation. So this eliminates the risk that may happen in early mediation, where you may not have all of the information that you will get later on. On the other hand, getting that information comes with significant cost. And a very small percentage of mediations occur post-judgment, after trial, pre-appeal, and even one or two after appeal. That is after maybe an intermediate appeal, but prior to a determination of a final appeal. That even then, parties can talk in an effort to try to resolve their disputes. Under the ABA rules of professional conduct, lawyers are required to make reasonable efforts to expedite litigation consistent with the interests of the client. Mediation advances the goal of expediting litigation by seeking to obtain a negotiated resolution. Even if mediation cannot entirely resolve the entire matter, mediation often will produce interim agreements that might head off the need for a motion practice related to injunctive relief. It may also take some issues off the table, thus narrowing the areas of disagreement. I recently had a mediation between a local municipality, its general contractor, and an architect over costs and expenses related to a municipal project. Of some interest, the contract between the municipality and the GC, general contractor, required pre-dispute mediation. Because of that, that they had to mediate, but the architect figured, let me go mediate, and I can try to resolve these issues too. And we were successful in resolving the architect's claim with the municipality, although we were not successful in resolving the GC's claim. So even there, sometimes participation in an early mediation may eliminate some issues or potentially eliminate one party's disagreements and narrows it. The ABA guidelines point out that the purpose of a settlement negotiation is to arrive at agreements that are satisfactory to those who the lawyer represents, that is, the client, and consistent with law and relevant rules of professional responsibility. Now, I think some key language there is to arrive at an agreement that is satisfactory to those who the lawyer represents. Not every dispute is going to resolve itself in a way that is 100% in the favor of the lawyer's client. Even the most successful litigation is not entirely going to be successful because the client is still going to have to pay the lawyer for the service. I could tell you any number of times when I was practicing law that when I got a terrific result, the client would say, yeah, that's great, but I deserve that result, and I had to pay you to get it. And of course, if you have results that are split decisions or are not favorable, the client's not happy. So no one is necessarily ever entirely happy with the way a dispute gets resolved. The question is, can you live with it? So the point of a settlement negotiation is to see if you can come up with a resolution that each client can live with. They may not necessarily be happy about, but can live with. And of course, the old bromide in the lawyer world is that a settlement that makes both sides unhappy is probably a fair settlement. In mediation, as with anything else in the law, lawyers are obligated to act with competence, to act with reasonable diligence in their representation of the client, and that includes acting with a commitment and dedication to the interests of the client, not necessarily the interests of the lawyer. Uh, Lawyers may think that the case should settle. Lawyers may think the case should not settle. Lawyers might have an interest in pursuing a case because they think it will achieve lawyer notoriety or will set a valuable precedent or because the lawyer has nothing else to do. That's not what we're talking about here. Reasonable diligence means you act with commitment to the interests of the client, not anybody else's interest, and that you dedicate yourself to that interest. I would point out that during my tenure on the appellate court dealing with attorney grievances, probably the largest category of attorney grievance was lawyers' failure to act with diligence. So this is something that busy lawyers need to take note of. Clients are not generally obligated to settle. When I was on the trial bench, it was easy for me. If a lawyer or a client said we don't want to settle, I'd say great. Um, you're entitled to your day of court, and it's my job to provide it to you. And there are people and cases that require a public airing, and that's fine. So clients have every right, if they wish. It's their money, it's their lives, it's their dispute to say no, I don't want to settle. Now, of course, uh, they may be required to at least participate in a settlement negotiation. There are agreements, like one I mentioned before, that may require that before a lawsuit is commenced, there be a pre-suit effort at mediation. I think the American Institute of Architects, the AIA, has that as a standard language in their arbitration in their architect agreements. And courts generally enforce those requirements. So if somebody brings a lawsuit and there wasn't a mediation effort, the court may either stay or even dismiss the lawsuit while that mediation process takes place. In addition, courts increasingly are compelling parties to participate in mandatory settlement conferences. Some courts have requirements that settlement conferences be held early prior to uh, significant litigation, meaning after the service of a summons and complaint. Others require mediation at a later date after the completion of discovery and while the case is being readied for trial. And some courts actually require both. Some courts require this in all cases. Some require them in, for example, employment matters. The Southern District of New York Federal Court has many, many employment-related cases, and there is now a requirement that those cases are mandatorily mediated. Unless there is a court directive or a pre-suit agreement, the decision whether to pursue settlement negotiations belongs to the client. So something a lawyer should say to the client early on is, how do you want to approach the issue of settlement? It is the proper practice to obtain the client's consent to enter into negotiations. Now, that means don't extend an offer to settle or offer to even talk about settlement unless you have the client's permission to do that. Where the client's permission is not required, as in there is a pre-suit agreement that requires mediation, or there is a court policy that requires mediation at various steps, the lawyer needs to explain to the client the significance of these requirements, as well as the penalties, if any, that may be imposed for failing to comply in good faith. When I was in the appellate division, we created a mandatory settlement conference part for cases that were ready for argument. And while we did not require anybody to settle, we did require that the lawyers and a client representative appear. If the client said, I don't want to appear, that we sanctioned. Um, and if a lawyer said, I don't want to appear, that we would sanction. So lawyers and clients perfectly within their rights to say, I don't want to go, I don't want to hear it, but they have to go. They don't necessarily have to hear. And while lawyers may think it's in the client's best interest to either pursue a settlement or to accept a particular settlement, a lawyer is not obligated to really compel the client to settle. The lawyer can say, look, I think it's in your best interest to settle, or these are the reasons why I think, in my professional judgment, you should embark on settlement negotiations or consider a particular offer. You're not obligated to press the client to accede, and you are obligated, in fact, to accede to the client's expressed interest. Where the client agrees to pursue settlement, a lawyer should act competently and with diligence in order to promote the client's interest, which hopefully and should be in obtaining an acceptable, remember, not perfect, acceptable, satisfactory resolution through a successful mediation. A lawyer's conduct in negotiating a settlement, whether through a mediated process with a third party neutral or just between the parties directly, should be characterized by honor and fair dealing. There are, as we will get into further in the program, some instances where attorneys have been sanctioned for inappropriate conduct during settlement negotiations. There have been instances where agreements reached during settlement efforts have been set aside by the courts because of fraud or other misconduct. But regardless of whether an attorney misconduct is sanctionable, regardless of whether the agreement may be set aside or vacated because of misconduct, settlement negotiations are much more likely to be productive, and a settlement more likely to be enforced where counsel act honorably and fairly. Mid-19th century U.S. contract law created a concept of the implied covenant of good faith and fair dealing. That, as the Court of Appeals expressed it in 1933 in New York, every legal contract, in addition to its precise terms, contains an implied promise that neither party will do anything which will destroy or injure the right of the other party to get the benefits that they were promised by that contract. And that implied covenant was included in the Uniform Commercial Code and incorporated by the American Law Institute into the Restatement of Contracts. And in collective bargaining matters, the National Labor Relations Act actually imposes by statute a duty of good faith on negotiators. So I think it's fair to say that a lawyer's conduct in negotiating a settlement should be categorized by honor and fair dealing. On the other hand, a lawyer's conduct in negotiating a settlement must be to further the interests of the client in obtaining the most favorable resolution possible. So it's necessary to balance the lawyer's advocacy and representation of the client with the lawyer's obligation to deal with others in a fair manner. The obligation to engage in fair dealing, or simply to use good faith, adheres at the moment when the parties agree to mediate. You might say once you start negotiating, everything becomes a negotiation. In my experience, communication between the parties prior to mediation is critically important. That if you're going to mediate or you're going to settle, you need to have the ground rules established. So, what are some typical ground rules that need to be established early on in the process? Well, how the process will be structured is important. Are we going to exchange offers? Um, is somebody going to make a demand? Is somebody going to make a counter demand? In what form is that demand? Are these demands going to take? In mediation, I've always found it helpful to have a mediation brief. Doesn't necessarily have to be very lengthy, but gives me um, some perspective on how each party views the case and views the salient issues and views the applicable law. Um, and those can be exchanged between the parties and provided to the mediator. So that way you're not wasting time. The mediator comes into the picture fully prepared and fully knowledgeable about each party's presentation and where they're coming from. I've also seen it where the offers are not set forth in mediation briefs, but in a separate document that's given ex parte to the mediator. So, for example, the mediator may be given an outline by each side of what the history of the offers have been and where each party thinks they're willing to go or not go. I've also at least seen those exchanged openly, at least where the parties have exchanged offers, where in the mediation brief, the party will say, well, look, my last offer was this, their last offer was that. And of course, it's always interesting when you get a mediation brief and the parties don't agree on exactly what the offers were previously. If nothing else, a mediator can be helpful in trying to improve and enhance the communications between the lawyers, because in the words of, from Cool Hand Luke, where the parties don't agree on what happened in the prior settlement efforts, what we have is a failure to communicate. And of course, it is also important to get an understanding as to who is going to be attendance at the mediation. I have seen circumstances where a principal of the client will be at the mediation and then will be offended when the principal on the other side is not available, is not at the mediation. And that tends to set things off on a bad footing. On the other hand, when you're dealing with a large corporate entity, it may be difficult to have a principal, and the principal may actually not be somebody who is in the operating arm of the company. The principal may be the in-house lawyer who is handling the matter internally for the company. For an insurance company, it may be the insurance adjuster or the person to whom the defense counsel is reporting, as distinguished from the insured, although the insured's presence may be important if the matter is likely to settle for an amount that's greater than the policy limits, or the insured's permission is required for a settlement even within policy limits, although the numbers of policies that have requirements for that consent is very few these days. So the mediation process can be defeated, as I pointed out, by a party's failure to communicate in good faith in advance of the mediation, and a lack of clarity in what's going to be discussed and how it's going to be discussed can create mistrust and mar the atmosphere for a productive conversation early on. When parties are engaged fully and openly, and everyone is approaching this above board, the opportunity for a successful resolution are enhanced. I'm going to move into a discussion now of settlement negotiations generally. But before I do, this is as good a time as any to talk about the New York codes. In order to comply with New York regulations, attorneys who are seeking CLE credit in New York need to be able to provide a code. The code is not intended for West Legal Education Center audiences, either live or on demand. I'm going to read the code twice and only twice, and I cannot repeat it or email it to you. So please take a note of it. So for those of you who are looking for credit in New York, please take note of the following code. A as in apple, S as in sugar, 33137 dash 71223. I'm going to repeat that again. A as in apple,
Basically,
S as in sugar,
and they sent her home.
33137 dash 71223.
And she has to go back and do all the pre-op surgery and have a second surgery.
Ethically, any change in circumstances that affects the agreement to mediate needs to be disclosed. So, for example, if somebody is going to change a prior demand or a prior offer, so suppose prior to mediation or early on in the mediation, a party proposes a settlement, but then decides, oh, I'm not going to honor that anymore. That needs to be disclosed. You can't allow the parties to proceed on a false assumption that an existing. I apologize for any technical issue that happened. I don't know why it happened. So the obligation to engage in fair dealing or good faith arises at the moment when the parties agree to negotiate. Prior to the commencement of mediation, we should discuss the making of initial demands, offers, and proposed settlement terms. How is the process going to be structured? Who's going to make a demand? Who's going to make an offer? And how is this going to be done? Is it going to be done orally? Is it going to be done in writing? As a mediator, I always found it very helpful to have a mediation brief from each side that lays out their perspective on the case and where they're coming from. Those can be exchanged openly because each party should know where the other side's coming from. And by the way, there's no great surprise there, presumably. Offers sometimes are communicated to me in a blind submission that only come to me, so I have an understanding of what offer or counteroffer each side is willing to propose and their take on previous offers. Sometimes it's done openly, at least in the instance where the parties are aware of what their current offers are. And it is very important to get an agreement as to who's going to be in attendance at the mediation. Cannot tell you the number of times that it's happened where someone is disappointed, angry, upset when a client shows up on one side and not on the other side. It engenders bad feelings. And so there should be clear expectations as to who's coming and who's got the authority to make agreements. The mediation process can be defeated by a failure to communicate in good faith. A lack of clarity can lead to misunderstandings that breed distrust and damages the environment that one needs in order to have a productive settlement discussion. Changes in circumstance that affect the agreement to mediate need to be disclosed, such as a change in a demand. Suppose the parties have agreed to mediate after they exchanged initial settlement positions, but going into the mediation, one side or the other has decided to retract that offer. That needs to be disclosed. A party, the other side may say, all right, well, listen, if that's your position, I don't want to bother going down this road because you're going backwards, not forwards. Likewise, new information or evidence that may strengthen or weaken a case affects the way counsel evaluate the case and should be disclosed unless there is some privilege or tactical reason not to. Examples of changes in circumstances range from, well, who's coming to the mediation? It was expected that person A was coming, but now they're not. Is person B coming instead? Why? Changes in insurance coverage or insurance issues. and changes in lien amounts where there is an assertion of a lien on a potential recovery. Adversaries never fully trust each other. As Ronald Reagan said, trust but verify. But negotiations must proceed in good faith. Bad faith tactics will derail a mediation quickly, and even if they don't derail the mediation, it will render a resolution vulnerable to being attacked. The biggest problems are in the area of representations of fact and omissions of fact. These create problems for lawyers because you may feel obligated by privilege not to disclose adverse information. On the other hand, failure to disclose it could potentially give rise to a claim of fraud and nullify any agreement that is ultimately achieved. Under the model rules of professional conduct, lawyers are not permitted to knowingly make a false statement of material fact or law to a third person. That would include an adversary or an adversary lawyer in a negotiation, or fail to disclose a material fact where disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, which relates to attorney-client privilege. So you can see that lawyers are obligated to disclose facts where it is necessary to avoid assisting the client in a material fraud unless there is a privilege issue. The ABA guidelines likewise prohibit the making of knowingly false statements. And the commentary provides some guidance as to how unethically false statements may occur. They may occur because a lawyer knowingly and affirmatively states a falsehood or states a statement that is partly true, but is misleading in a way that's the equivalent to an affirmatively false statement. A lawyer incorporates or affirms the statement of a third person, another, whether it's the client or somebody else, that the lawyer knows to be false, and in certain limited circumstances, by remaining silent and refusing to disclose facts to a third person. In the context of negotiations, a lawyer representing a client may not make a false statement of material fact to a third person. But the key words here are material fact. Statements regarding a client's negotiating goals. My client wants to get a settlement that nets the client X. My client wants a settlement on which the client will pay Y. Those kinds of statements are generally not regarded as statements of material fact. They are considered puffing or just negotiating statements that everyone knows they should be on their guard not to take seriously. Even a statement along the lines of my client doesn't want to settle, when in fact the client does want to settle, or a statement that says my client does want to settle when the client doesn't want to settle. Those are generally not regarded as statements of material fact. On the other hand, there are some types of statements that can result in discipline because they are materially false. An example of this is matter of Gilley case from the Southern District of New York. An attorney was suspended from the practice in the federal court. He was representing the plaintiff in an employment discrimination case and was using an expert report in order to obtain a favorable settlement. That expert report talked about damages that were ongoing into the future because of the plaintiff's inability to obtain a replacement position. But in fact, as the lawyer knew, the plaintiff had already accepted another position, which of course would impact the amount of future damages that the client could get. So for misrepresenting by failing to disclose the fact that the client had gotten another job, the lawyer was suspended. In fact, the court initially exercised some mercy accepting the lawyer's plea that his conduct was inadvertent. However, he was again suspended for a second year after it came to light that his claim of inadvertence was false. In another case, this one from Kentucky, a lawyer was publicly reprimanded for failing to disclose that the client died prior to entering into and consummating settlement negotiations. In order to settle, you have to have a client. Clearly, when a client has died, the lawyer no longer has any agency on behalf of that entity, and the claim doesn't belong to the lawyer. The claim belongs to the estate of the client, and the lawyer therefore had no authority to do anything. It's a material misrepresentation. ABA Formal Ethics Opinion 06439 says that certain types of statements generally are not taken as statements of fact. Examples that they give are estimates of price or value. For example, I think my car is worth $500. I think that house is worth $1 million. Generally, that's just an estimate of price or value. And so a statement of an intention as to what would be an acceptable claim also falls into that category. My client will settle this for this amount of money, when the client would actually settle for less, or the client will pay this when the client would actually pay for more. Generally, that's not the sort of thing that is a problem. But be careful, there are limits to this. So an estimate by a party as to what they think something is worth is generally not a statement of material fact. But suppose the lawyer were to say, not only does my client think that that house is worth $1 million, we have an appraisal report that says it's worth $1 million. If, in fact, there is no appraisal report, or the appraisal report values it at less, that may well be a statement of material fact that is false and actionable. It is not unusual, says by way of explanation, says the ABA opinion, for a party or through a lawyer in the course of a state negotiation to communicate a position that is not entirely forthcoming. For example, plaintiff might say, I'm not going to take less than $200, when in reality, the plaintiff will take $150. But as I said, those things are generally regarded as puffing. A party's exaggeration or emphasis on the strengths, or a party's minimization of its weaknesses of its position are not actionable generally. We don't have to deal any business with you. We can get what your client is selling someplace else. Generally, that's not a statement of fact. On the other hand, in a labor negotiation, saying to the union lawyers that the cost of adding a particular benefit would be $100 per worker, when the lawyer knows that the cost would actually only be $20 per employee, that's a statement of material fact. Or posturing by representing that evidence will be submitted at trial when the lawyer knows that the documents don't exist, that's a statement of material fact that can be sanctioned. The issue about admissibility is a little trickier. Suppose I have a document that I do intend to offer, but I think is likely to be inadmissible. The ABA says that would fall into this category of a misstatement. On the other hand, if I offer a document and the other side doesn't object and agrees to its admission, it becomes admissible, right? So I'm not entirely sure about the use of inadmissible materials, or arguably inadmissible materials, particularly where it is possible that the objection may be waived or not timely asserted. Demands and offers. Good faith means keeping your word and honoring offers and demands. Bad faith is being a moving target. Well, I think I'll take this today. Nah, I don't mean it. If you make a demand, don't change it on the day of or during the mediation. That's a little different than giving yourself room to negotiate. So, for example, if you put out an offer and say, well, I'll settle this case for $10,000, knowing that you will take eight, that's okay. But don't say one day I'll settle this case for 10 and then tomorrow say now it's 20 without, and then going back to a different number without a valid reason or explanation. In fact, good faith says if you change your demand or offer, to explain why, because that way the other side can either reevaluate their position or postpone the mediation or decide not to mediate. There are things that may justify a change in an offer. Suppose in a personal injury case, you find out that your client needs to have another operation, or that the client has now told you of a fact that you were not previously aware of. Or take the case that I mentioned earlier. You're insisting that your client is entitled to future damages because your client is unemployed, but then you find out that your client is employed. That's actually going to require that you change your position. So good faith, another aspect of it is disclosing a special condition or terms of a settlement that you wouldn't ordinarily expect. For example, suppose as part of a settlement, you're going to demand a non-disclosure agreement. Or suppose as part of a settlement with an employee, you want the client to agree, you want the employee not to accept employment with another competitor for a period of time. Those are terms you might ordinarily not expect in a settlement. So don't wait to spring that on somebody. Disclose it early on. Likewise, good faith requires disclosing issues that pertain to insurance as soon as you become aware of them, rather than hiding them and keeping them hidden. So in New York, we had this case where in a medical malpractice case, the attorney representing the hospital, which who was hired by the primary insurer, said, well, the total amount of coverage for the hospital was $200,000, which was in fact the amount of the policy. However, what the attorney didn't say was that there was a $1 million excess policy, which would kick in as soon as the primary policy paid $200,000. But because the plaintiff thought that the maximum available coverage was $185,000, was $200,000, the attorney agreed to a settlement of $185,000. After the truth was discovered, the plaintiff kept to the settlement with the hospital, saying, all right, I settled, it's 185, bearing in mind that the policy would have been 200, so the attorney was only shorted by 15. But the plaintiff succeeded in obtaining a recovery from the insurance company, the primary carrier, and the defense attorney and the defense attorney's partner, based on their failure to timely disclose the existence of the excess policy. Good faith and bad faith permeate negotiations, and it's a little bit of what Potter Stewart once said about obscenity, which is you know it when you see it. Under the ABA guidelines, it may be impermissibly deceptive and bad faith for a lawyer to obtain participation in settlement or mediation by representing that the client is genuinely interested in pursuing a settlement when the client actually has no interest in doing so, and settlement negotiations or dispute resolution processes are merely sought as a reason to delay. That is the bad faith use of a settlement process. So if your client says, look, I don't really want to settle this case, You say, okay, that's your business. Let's not do mediation. And if the court requires us to attend a mediation session, let's be frank and say there's no way that you're interested in settling. Now, that doesn't mean that the mediator, when talking to the client, won't say, hey, let's get behind this and let's talk about why you don't want to settle and whether there is any way to address your concerns. But you can't employ the settlement process solely as a means of dragging the case out. Other articulations of bad faith: intentional deceit, misleading to obtain an advantage, negotiating without any intent to compromise, arguing a position that one knows to be false. Ethics rules, procedural rules, and statutes prohibit the bad faith use of the litigation process. How can we detect bad faith? Well, we know that we see it because bad faith negotiators will often be unresponsive or slow to respond. So in a settlement discussion that's not mediated, the adversary party, when you relay an offer, says, well, I'll get back to you. And then they don't get back in a timely way. Oh, I was on vacation. Oh, my client was on vacation. Oh, we're thinking about it. A failure to timely respond may be indicative of an effort to engage in the process solely for the point of view of dragging it out. Changing the topic or referring to unrelated issues may be a sign of bad faith, as will referring to things that they claim are outside their control. Well, we would love to settle, but we've got to do X, Y, and Z before we can approach a settlement. Under the ABA guidelines, an attorney cannot ask opposing counsel to consider a possible settlement where the proposer has no intention of agreeing to it. Hey, how would your client feel about settling this case for $100,000 when the offerer knows that his or her client has no intention of agreeing to that amount? That's clearly bad faith. And don't get the mediator involved in conveying an offer, and tell the mediator, listen, why don't you approach the other side about seeing if they're interested in settling this case for $100,000? When the lawyer, in fact, knows that the client will not honor that if it's accepted. Likewise, don't keep all the terms from being disclosed until everything else has been agreed upon. That's like the famous, well, there's one more thing I want to put out there. Put all the terms out there. While nothing is agreed until everything is agreed, typically, it is bad faith not to mention a key term until everything else has been negotiated. Lawyers may not attempt to obtain a settlement by extortionate means, such as by making extortionate or otherwise unlawful threats. So, for example, that means you can't threaten a lawyer or a client with criminal prosecution or the divulgence of embarrassing information in order to coerce a settlement. But there, it is not necessarily inappropriate, or actually may be appropriate, to point out, to say, listen, I want you to know that if this goes to court, the press may be there, and if the court is open, this information may come out in the press. That's not a threat. That's simply pointing out that courtrooms are publicly open, and information that is revealed in courtrooms may become public. Likewise, statements about the theory of the case that may be disclosed. Suppose the case involves trade secrets, and a defense lawyer may say, well, listen, I know your client is claiming all this stuff is a trade secret, but if this gets out into the public in the course of the dispute, they may lose more than they gain. That may just simply be a practical analysis of the consequences of litigating in a public courtroom, not a threat that I or that the client will make that information public. In the settlement context, lawyers should not exploit other parties' material mistakes of fact that were induced by the lawyer. So, for example, a misrepresentation that there was an appraisal report that says X, Y, or Z. We talked about that. Now, you can exploit other people's mistakes, but you can't exploit them if you've actually induced them and thus caused them. Lastly, and this is very, very important, a lawyer must keep the client informed about settlement discussions and must promptly and fairly report settlement offers. Under the ABA guidelines and under the model rules, an oral offer must be communicated if it is a significant development relating to the representation. I cannot conceive of a circumstance where an oral offer of settlement is not a significant development relating to the representation unless the oral offer was, by its own terms, ridiculous. So, for example, if somebody said, I'll settle this case for $3 billion, and obviously the case was never close to worth $1 million, then I think a lawyer could say, I'm not going to communicate that to my client. That's insulting. But generally speaking, oral offers should be communicated to the client, and that can be done in an offhand way, such as, oh, the lawyer said to me that they'd be willing to do settle this case for $3 billion, just to show you what they think. And written offers need to be disclosed as well, which is simply done in this day of email, where you can simply email the offer to your client. Lawyers can only act within the broad general authority given to them by their client. One of the things that's important is to recognize that it's the client who settles the case, not the lawyer. Now, there are some circumstances, typically in courts, where a lawyer has the authority to enter into a settlement on the client's behalf. Suppose there is a court conference and a settlement is reached, and the lawyer then puts the settlement on the record before the court. In some jurisdictions in New York, that can be binding, because the rules will stipulate that when a lawyer shows up in court, they're representing that they have the authority to make binding commitments on behalf of the client. But a lawyer should not do that unless all of the agreement's terms unquestionably fall within the scope of the authority of the lawyer. So the client says to the lawyer, look, you don't have to call me, but if you can accept any amount above $100,000, then that's okay. Or if you don't have that kind of authority, get the client's specific consent. And be aware of the potential that your client could change the position for your own protection. Get the client's consent anyway. I had a lawyer who was a mentor to me who would somewhat cynically told me, today's client is tomorrow's adversary. I'm not so sure that I'm so cynical, but there is always a concern about buyer's remorse, meaning you come back and you say, I got great news. You told me you would accept any amount over 100,000, and I got 110. And the client says, great, but I really thought I could get 200. And you committed malpractice by not telling me. So I think it's important for you, for your own interests, as well as the client, to ensure that you've explained all of the terms to the client and that you've gotten the client's consent. That's why I also think that in a mediation setting, the client should be present either during it or available at its conclusion so that all of the terms can be stated to the client. Lawyers should provide their client with a professional assessment of the pros and cons of a proposed settlement. At the end of the day, it's the client who makes the decision about a settlement. you can appropriately assist the client in making that decision by saying, here are the pros, here are the cons, but it's ultimately up to you to decide. As a mediator, I often get asked to participate and help a client deal with the issue of settlement. But again, I try not to interfere and intrude on the role of counsel, and I can point out the pros and cons from the point of view of a neutral, pointing out that I'm not there to give legal advice, and I'm not there to advise the client whether to accept or reject it. That's something that the client has to do. But I can try to point out strengths and weaknesses. A lawyer who represents two or more clients should not counsel the clients about the possibility of a settlement if the representation of one may be materially limited by the lawyer's responsibilities to the other, unless the lawyer reasonably believes that he or she can provide competent representation to both. In other words, don't put yourself in a position where clients' interests fundamentally conflict. It is fundamental that you avoid that. So, for example, if you're representing two plaintiffs and there's likely to be a dispute about which of the clients should get more money out of a limited settlement pool, there may well be a client conflict. Likewise, you have the same issue on the defense side when you're dealing with insurance situations. The insured is really the client, even though the insurance contract obligates the insurer to provide the lawyer and pay the fees. Now, in some jurisdictions, the insurer may be the client, but where that is the case, the lawyer needs to be governed his or her conduct by the relevant rules provided by the model rules. In the course of negotiating a settlement, a lawyer must disclose a material fact where it's necessary to avoid assisting a criminal or fraudulent act. I think I've said that before. I think this is going to be our last topic relating to legal fees. When an attorney's fee is the subject of settlement negotiations, the lawyer may not subordinate the client's interest in a favorable settlement to the attorney's interest in the fee. Example, you should not let your fee influence your conduct in negotiating a settlement. And you may not agree to refrain from reporting opposing counsel's misconduct as a condition of a settlement, in contravention of a lawyer's obligations to report attorney misconduct under the applicable rules. In most jurisdictions, lawyers have an ethical obligation to report a lawyer's serious misconduct to the appropriate authorities. These obligations are mandatory and cannot be vitiated by a private agreement, including by settlement. Therefore, a settlement agreement cannot be conditioned on a commitment not to report misconduct unless the information falls outside a mandatory reporting obligation. And then lastly, in representing a client, lawyers may not use means that have the primary purpose, or actually no other purpose, other than embarrassing, delay, or burdening a person. And in California, it takes it further to say that that has no purpose, no substantial purpose, other than to delay or prolong the proceeding. An issue that comes up as a subset of this is what happens when you receive a document by mistake. A lawyer under the ABA model rules, a lawyer who receives a document and knows that the document was inadvertently sent is required to notify the sender, although the rules do not specify what, if anything, you're supposed to do other than notification. Meaning, can you read it? Can you copy it? Can you send it to your client? In California, where it's apparent that you received something by mistake, then you are required to refrain from examining it any more than is necessary to determine that it is privileged or subject to work product, and then promptly notify the party you received it to. And you may not agree as part of a settlement to return or dispose of documents. I'm sorry, I stated that incorrectly. Unless otherwise unlawful, you may agree as part of a settlement to return or dispose of documents produced in discovery. That is to say, if parties have exchanged confidential information, they can agree, generally speaking, to destroy or return documents that they so received. We've now run actually past the allotted hour. I've checked to see that I don't have any pending questions that have been asked. I would like to thank each of you for your attending this program. It has been a great privilege on my part to present on this topic. And if anyone has any questions or if I can be of use to anyone in the future, please feel free to contact me through NAM. Thank you all very, very much.